Hi, I'm attorney Bill Bronchick, and in this lesson I'd like to share with you 7 different ways that you can get in trouble wholesaling houses. Now, wholesaling houses is completely legal, it is ethical, it is a legitimate business, but the problem is that people do it in ways that are questionable. When I first started teaching wholesaling some 12 years ago, it was either one of 2 methods. Quite simply, you had a seller, you had you, and then you have an end buyer who's an investor, not an owner-occupant. So it would work as follows. You put a contract together between you and the seller, and then you put a contract to resell between you and the investor. And then you do what's called a double escrow or simultaneous closing using B's funds to fund the front end closing. It's getting a little more difficult to do those double closes these days because a lot of title companies don't like it, but it is still a viable way to do it. Now, a lot simpler than this, if you're dealing with a for sale by owner seller, if this is a FSBO, then you simply put a contract together between you and the seller and then assign your position as buyer, assign it to the investor who becomes the assignee under the contract, and then he closes directly with the seller and you get paid. Very simple. It's 2 ways to do it. I've been teaching that for years, doing it for years, my students have been doing it for years, but the problem is people have created variations of this that might get you into trouble. And let's talk about those 7 different variations so you know what to do and what not to do. Okay, so the first one is trying to wholesale something that you don't have under contract. See, in this example, you're selling what you have, a contract with a seller, assigning it to another investor. You're selling the contract. Or you're selling the property to someone else in a double close, but it's contingent upon you acquiring the property first. Okay? Now, some people think that you should disclose that you only have it under contract with the owner. You don't own it yet. That's probably not a bad idea, but if you're dealing with another investor on the back end, they understand that, but you should probably disclose that. Now, should you advertise I have a deal for sale versus I have a house for sale? Well, now we're getting into the nitty-gritty of splitting hairs here, but I think the important thing is to make sure that everybody understands the transaction. Okay? So if you have a property under contract to purchase, and there's no prohibition of assignment in the contract, it means it's freely assignable, then you can assign it to another investor, another buyer. However, if you don't have anything under contract, you don't have a deal. What you're doing is basically brokering, which requires a license in every state. Now, some people would say, well, I'm just getting a bird dog fee or a referral fee. Guess what? Those things also require a license in most states. So what you can do, however, so the first one is don't wholesale what you don't have under contract. What you can do in most states, if you have a seller that wants to sell and you give that information of that lead that you've gotten information about, their problem, the house, what they want, and then sell that to another investor who closes with the homeowner, well, that's different. You're selling information. That's a marketing fee. And can you get paid at closing contingent upon it? That's called a marketing success fee. I still think that's okay. But if you pre-negotiate things with the owner and then switch, I'm not going to be the buyer, someone else will, and then getting paid at closing, that's brokering. That's by definition brokering. Okay, so you don't want to do that. You want to avoid making sure that you have a deal, especially if you're dealing with an end buyer who is going to live in the property. We'll come back to that in a moment. but especially in that case. Number 2, the next one would be stepping out of the contract that you have with a seller and then creating a new contract between the seller and the end buyer. So stepping out means you have a contract with a seller. Instead of assigning it to the buyer, for whatever reason, the buyer needs to get financing, and if you assign it, it won't work, and you do a double closing, it won't work. So the owner has to close directly with the end investor. So what you do is you tear up your contract between you and the seller, prepare a new one between the seller and the end investor, and then you get paid at closing. Guess what? That's a brokering activity. You brokered that deal. You should not do a deal like that. Very, very risky. You will get in trouble with state real estate commission. As soon as there's a realtor involved and you step on their sign, they're going to complain and you're going to get a cease and desist letter from the state. Okay? Now, there is an exception to that. And I talk about this in my wholesaling course. It's called the reverse assignment. So a regular assignment is when you have a deal under contract with the seller and then assign your position as buyer to another investor who becomes the buyer and closes with the seller. That's perfectly okay. You're selling your contract. A reverse assignment works backwards. What you do is you go to the seller and say, I'm going to assign my contract with the end buyer as seller to you. And then you're going to close directly with the end buyer, and you're going to pay me X dollars for assigning you my contract. And of course, you're going to cancel the contract between the seller and you in the first place. So in consideration for canceling the contract, assigning your position as seller with another party, you get paid an assignment fee on a reverse assignment. Now, if that confused you thoroughly, don't worry. You can find more information and the forms to do that in my wholesaling course. Okay? So stepping out, bad idea. Number 3, wholesaling to an end user who's going to live in the property who's not sophisticated. Now, I wouldn't say you should never do this, but you should try to avoid doing this because you've got a seller who's not sophisticated. You've got an end buyer who's not sophisticated in real estate. And you're the one in the middle, and they're going to get confused about what your role is. Are you a broker? Or you have a broker's license? I'd say generally avoid that. Deal instead of assigning to other investors, although there might be a circumstance where the end buyer in a higher end home might be sophisticated enough to understand it. Maybe they're a real estate broker. But generally speaking, I just don't like wholesaling to owner occupancy. It can be done in circumstances if the proper disclosures are done. But as a general rule, especially as a beginner, I think you should avoid that. Okay. So avoid selling to owner occupant. That's number 3. Number 4, not disclosing or disclaiming about any defects or risks on the property to the end buyer. Now you're probably thinking, wait a minute. If I assign my contract that I have with the seller to another investor, that investor has the duty to go do their due diligence, and they're a grown-up, they should understand what the risks are. Not necessarily. I've represented many clients who've gotten threatened lawsuits or actually been sued by the end investor for not disclosing things that they knew or should have known. So if you just have a simple assignment form that says, for $10 or for $1,000, I assign my right in the purchase contract to you, the investor, and that's all you do, then you're going to have problems later on. Once in a while, it's going to come back to bite you. So you should have really good disclaimers and disclosures that you're not representing anything about the house, the foundation, the condition. They take it as is. You're not making representations about the repairs, the neighborhood, etc., etc., etc. Okay? I have an excellent assignment form in my wholesaling course exactly for that purpose. So not disclosing. I'm going to put not disclosing / disclaiming. Okay. Number 5. If you're doing a double close, not disclosing to the end buyer that you don't own the property yet. Okay? Now, do you need to disclose to the owner, the seller, that you intend to resell the property in a double close? I don't think so, but it doesn't hurt to put that in there. That you may assign it or that you may double close and resell it. It doesn't hurt. The seller doesn't really care. Trust me, they're motivated, they don't care. Unless the seller is a bank or a sophisticated party, they may object, but a for sale by owner won't care. Okay, so should you disclose to the end buyer? Well, if the end buyer is an investor, they're going to know that you're wholesaling what you have, so I don't see the harm. Again, it comes to the situation where you're going to double close to an end user occupant, which I already said I don't like. But if you do that, make sure you disclose that the contract with him is contingent upon you closing with the seller first. Okay? Because if it blows up for some reason and you didn't disclose that, and the end buyer, relied on your representations and spent money in inspections and moving and everything, and then you blew it up, you're going to get in trouble legally. All right? So, not disclosing. You don't own. Okay, that's number 5. Number 6, either a short sale on the front end or a Fannie Freddie property. Now, when you do a short sale on your deal with the seller and then plan to resell it, almost every lender in their short sale approval letter is going to have language that says you may not resell this within a certain time period, or you may not resell it for more than X dollars, or you may not assign it, you may not double close it. You have to read the language and see exactly what it prohibits and what it doesn't prohibit. Okay? Depending on the language, there are ways around it. If it's a Fannie Freddie property, usually they say you cannot resell the property within 90 days for more than a 25% markup. Now, that's not a big deal if you're wholesaling in a double close, of course, right? Because you're not going to mark it up 25%, maybe 5 to 10. And if you assign the contract, well, then it's not a problem because the end buyer's closing directly with the seller. But just keep those in mind if you come across those. If you've got either a short or a Fannie Freddie loan. Not a loan, but a Fannie Freddie owned property. And finally, number 7, putting the contract in your own name versus doing it in an entity. That's a big mistake. Now, the reason is, if the deal goes bad, keep in mind, if you have a contract with a seller, and then you assign it to a third party, and that third party doesn't perform, you're still liable on that contract with the seller. You have to specifically, number 1, use an entity so to limit your liability, and make sure you sign in a representative capacity as manager of the LLC, as president of the corporation. But you should also get something in writing after you assign it that says that the end buyer and the seller both hold you harmless and absolve you of any liability under the contract from here on out. So that way, if it goes bad, they can't point their fingers at you and say, hey, you're liable too. So it gets you off the hook to some extent. Okay? Also, if you use an LLC, for example, so number 7 is not using an entity. If you use an LLC, you can get around a non-assignment clause that the seller may have. For example, the short sale or a lender-owned property where they say, you may not assign this contract. You can't. Okay, can you double close it? Well, in theory, yes, but if the seller, the bank, picks the title company, and odds are they're not going to understand or to want to do a double close, what do? Well, you sign up the contract with your LLC, a special single-member LLC that you just formed just for this deal, and then the contract's between the LLC and the owner, the seller, and then you sell or assign your membership in that LLC to another investor, and they close directly through the LLC with the seller. Okay? Now, if that sounds a little confusing or you're not sure of the logistics, my wholesaling course covers this and all the forms from A to Z. Go check it out at legalwiz.com/wholesaling. I hope you've enjoyed these 7 potential pitfalls and you avoid them like the plague. This is Bill Bronchick. Email me if you have any further questions.